You've probably heard about celebrities, politicians, or wealthy folks heading to Canada or some other country just days before their baby's due, having the baby there, and then quickly returning. One of the most interesting and hotly debated ways to gain citizenship in a country is simply by being born on its soil. Basically, the moment your feet touch the ground, you're practically stamped a citizen. But what's the story behind this law, known as birthright citizenship or jus soli, right of the soil? Where did it come from, and which countries still stick to it? We're going to dive into the history and laws of the US, Canada, and even the grandmother of this law, Britain, to see where this tale of birthright citizenship originates and why it's so darn controversial. So, which countries currently grant automatic citizenship when a baby is born? Let's start with America. Any child born in the U.S. automatically becomes an American citizen and gets a U.S. passport, based on the right of the soil principle. So, where does the story of this law begin? Right from that turbulent era after the American Civil War. Imagine, the country was split in two. Northerners and Southerners fought each other. So much blood was shed, and finally, the North won. Now, America had to somehow get its act together again. Americans added 3 crucial and fundamental amendments to their Constitution. It was as if they wanted to do a major spring cleaning of their laws. These amendments, among other things, define some very important rights and privileges for Black Americans who had been enslaved until then. The first one completely uprooted slavery, basically said, enough is enough. The second gave Black men the right to vote, which was revolutionary at the time and caused a huge stir. And the third, which is central to our story and has been the subject of much debate, told African Americans, that is, former slaves and their descendants, you too are citizens of this country with all its rights and privileges. Now, let's get to that third amendment, the 14th Amendment, which is what our story largely revolves around. This one was a bit special. It didn't come right out and say, hey, Black people are citizens, nor did it name any specific race. They were clever about it. Instead, they laid down a general rule that, with a few small exceptions, stated that any child whose feet touched American soil at birth automatically became an American citizen. Done and dusted. This is called birthright citizenship, or as the experts say, jus soli, meaning right of the soil. It means it doesn't matter who your parents are or where they come from. The moment you're born here, the stamp of American citizenship is on your birth certificate. It's like anyone born in your house automatically becomes a member of your family, regardless of whether they were guests or not. Fast forward to the present day. The issue of birthright citizenship has heated up again, big time, especially with Donald Trump's pronouncements. He previously said that if he made it back to the White House on day 1, he'd issue an executive order revoking this law for the children of those who are in the U.S. temporarily, or, as he puts it, illegally. What does that mean? It means if parents have a tourist visa or even came to America without a visa, their child would no longer be an American citizen. Of course, Trump's proposed order has hit a snag. Several federal judges have stood up to him, saying, look, birthright citizenship is one of the pillars of our democracy. You can't just get rid of it like that. In short, the tug of war over this issue continues, and it's unclear how it will all pan out. But this fight over citizenship is nothing new. It's been in the nation's DNA from the get-go, in a way. Let's take a trip back to the past to 1857, a few years before the American Civil War kicked off. Back then, America was a divided country. Some states allowed slavery, while others had banned it. In this environment, there was an enslaved man named Dred Scott. His owner had taken this poor fellow from a slave state to a territory where slavery was prohibited, meaning slaves were considered free. Mr. Scott, being a sharp guy, filed a lawsuit saying, "Hey, I've set foot on free soil, so I'm no longer a slave and should be free." His case went up and down the courts until it reached the U.S. Supreme Court, the highest court in the land. And what do you think happened? The Supreme Court issued a ruling that hit like a bombshell. They said not only were Mr. Scott and his family not free, but they weren't even considered U.S. citizens who could sue in court. To top it off, they let it all out, stating that no person of African descent, whether enslaved or free, could be a U.S. citizen. They basically said some people just didn't count as human beings in this country. This Dred Scott decision, among other issues, pushed the country towards civil war, a war where one side wanted to eliminate slavery and this very discrimination. Long story short, the war happened. The North won, and now they had to figure out what to do about the situation. The first step was passing the Civil Rights Act of 1866. This law stated that anyone born in the U.S. was a citizen, except for Native Americans, who were considered separate at the time. This was an attempt to get around the Dred Scott ruling. But there were two big problems. First, the president at the time, Andrew Johnson, opposed it. He was worried the law would grant citizenship to Chinese and Gypsies, Roma as well. Though, Congress overrode his veto with a larger majority. The second, more significant problem was that this was just an ordinary law, meaning another Congress in the future could easily come along and repeal it. That wouldn't do. That's why they decided to nail down this principle of birthright citizenship somewhere more solid, in the Constitution itself. And so, the 14th Amendment was born. Its text was what we mentioned earlier. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. What's the key phrase here? Subject to the jurisdiction thereof. That's the part that's still debated today. But back then, for this amendment to become part of the Constitution, just a vote from Congress wasn't enough. 3/4 of the states had to ratify it too. The southern states, having just lost the war, were in no mood to agree. So, Congress basically said, "All right, if you want to have representatives in Congress again and be considered part of the country, you have to swallow this amendment and ratify it." It was a bit forced, but hey, those were wartime conditions. Interestingly, during those very debates in Congress, one senator asked, "Won't this amendment make the children of Chinese and Gypsies citizens too?" Another senator replied, "Undoubtedly. The law makes no distinction. The child of an Asian is as much a citizen as the child of a European." So, they knew exactly what they were doing and intended for this law to include everyone. Now, let's turn to another true story that became the first serious challenge to this amendment. In 1882, Congress passed a law called the Chinese Exclusion Act. This law stopped the immigration of Chinese laborers and prevented those already here from becoming citizens. A few years later, a Chinese man named Wong Kim Ark, who was born in San Francisco and worked as a cook, went to China to visit his family. When he tried to return to the U.S., they told him, "Nope, sir, you can't come in anymore." Mr. Wong said, "What do you mean? I was born here. According to the 14th Amendment, I'm an American citizen." His case went all the way to the Supreme Court. The main question was Wong Kim Ark, whose parents were Chinese immigrants and not U.S. citizens, subject to the jurisdiction of the U.S. when he was born? Or, because his parents were Chinese citizens, should he also be considered a Chinese citizen? In 1898, the Supreme Court delivered a landmark ruling. They said Mr. Wong Kim Ark was an American citizen, period. What was their reasoning? They stated that the 14th Amendment only excludes 3 categories of people from birthright citizenship. First, the children of foreign diplomats, because they are under the jurisdiction of their own country. Second, members of certain Native American tribes, who were treated like separate nations at the time. And third, children of enemy forces occupying a part of the U.S. Mr. Wong Kim Ark didn't fall into any of these categories. His parents, although not citizens, lived in the U.S. and were subject to its laws. Therefore, their child, born here, was also a citizen. The Supreme Court even referred to those congressional debates where senators had said the law would include the children of Chinese and other immigrants. This Wong Kim Ark ruling became the cornerstone for interpreting birthright citizenship. Since then, for over 100 years, all courts and government officials have followed this precedent, meaning if you're born on U.S. soil, you're a citizen, unless you fall into one of those 3 specific categories. This legal consensus is very strong and has been repeatedly affirmed in various courts. However, as we said at the beginning, public consensus is a different story. Especially since the 1980s and 90s, when the number of undocumented immigrants, i.e., those who entered illegally, increased, voices opposing birthright citizenship grew louder again. Some argue that subject to the jurisdiction thereof doesn't apply to those who entered illegally. Others claim the amendment was only intended for former slaves and shouldn't be extended to others. In a nutshell, this debate over birthright citizenship is, in a way, America's perennial story. On one hand, there's a solid constitution that says right of the soil. On the other, there have always been and still are people who oppose it or want to change its interpretation. As we mentioned, currently about 40% of Americans have an issue with this. And of course, Trump's pressure and insistence might lead to changes in this law. All right, now that we've talked about America and all that back and forth over birthright citizenship, let's pop over to its northern neighbor, Canada. How are things over there? Are they like Uncle Sam, considering anyone born on their soil a genuine Canadian? Or do they have a different system? Folks, rest assured, Canada is also one of those countries where if your child is born there, they automatically get a Canadian passport, meaning the principle of right of the soil, or jus soli as we know it, is firmly in place there too. In this respect, Canada and the U.S. are like 2 brothers who agree on an important law. Canada's story is a bit different from America's. They didn't have a bloody civil war or a hugely controversial amendment like the 14th for this issue. Canada's Citizenship Act, first passed in 1947, before which Canadians were mostly considered British subjects, incorporated this right of the soil principle, inherited from English common law from the very beginning. It was sort of in their legislative DNA. This English common law, in turn, has roots going back to the Middle Ages, which stated that anyone born within the king's realm was considered a subject of the king and owed allegiance, and in return, the king would protect them. this concept gradually evolved into citizenship. So, Canada's situation is much more straightforward than America's. No sensational court cases like Dred Scott, no heated debates in Parliament like, "Sir, does this include the Chinese or not?" From the outset, they said anyone born here is a citizen, with a few very specific exceptions. Like what? For instance, the children of foreign diplomats. Well, obviously, diplomats represent their own countries and are under their own country's laws, so their children become citizens of that country, not Canada. This is pretty much a universal rule. Of course, this doesn't mean there's absolutely no discussion or controversy about it in Canada. In fact, for several years now, there have been debates about birth tourism. What's that? It means families who aren't Canadian citizens, especially from countries where it might be hard to get a visa or who want a better future for their children, plan for the pregnant mother to come to Canada close to her due date so the baby is born there. The child automatically becomes a Canadian citizen with all its benefits, like free education, healthcare, and the right to live and work in Canada in the future. Some Canadian politicians and citizens say, hey, this is an abuse of our hospitality and laws, and that it needs to be stopped. They argue it puts an extra strain on the healthcare system and isn't fair. Even Canada's Conservative Party has raised the issue of potentially changing the law a few times. Their proposal is that birthright citizenship should only be granted to children if at least one parent is a Canadian citizen or permanent resident, something similar to the law currently in place in many European countries, Australia, and New Zealand. They say this would prevent citizenship shopping. However, to this day, these discussions haven't led anywhere, and Canada's citizenship law remains firmly in place. There are various reasons for this. One is that changing this law isn't that easy. Many legal scholars say that because this right of the soil principle is so deep-rooted and part of Canada's legal identity, it might even require a constitutional amendment, which is itself a Herculean task and not easily done. Another reason is that there aren't precise statistics on how widespread birth tourism is, and some argue it's not such a big problem that it warrants changing a fundamental and important law. Besides, Canada is known for being welcoming to immigrants, and such changes could damage its international image. So, for now, Canada, alongside the US, is one of the few developed countries that still strictly adheres to the right of the soil principle without additional conditions, meaning being born on Canadian soil is still the golden key to citizenship, regardless of where the child's parents came from or their status. In a way, Canadian soil still has magic. Okay, now that we've toured the US and Canada and seen what they do about birthright citizenship, it's time to visit the grandmother of this law, Britain itself. After all, this right of the soil principle started on Miss Foggy Isle and later spread to the rest of the world like a good virus. At least in some people's eyes. Folks, Britain was once the king of right of the soil. I mean, since the Middle Ages, back when knights in shining armor roamed the land, this unwritten but very serious rule existed. Anyone born within the realm of the English monarch was a subject of the monarch. What did that mean? It meant they had to be loyal to his or her majesty, pay taxes, and, if necessary, take up a sword and fight for them. In return, the monarch had a duty to protect them and ensure their security. It was a kind of two-way contract. Later, as the world modernized and the concept of subject gradually gave way to citizen, this principle was updated along with it. But Britain's story has an interesting twist. Unlike the US and Canada, which still cling tightly to this right of the soil, albeit with some debate, Britain, somewhere along the way, changed course. Until 1983, things in Britain were pretty much as we described. Anyone born on British soil became a British citizen, with all its perks. It didn't matter who their parents were or where they came from. In a way, British soil had a magical power that turned every newborn into a citizen. However, in the 1960s and 1970s, with increasing immigration from Commonwealth countries, those former British colonies, some concerns and political debates began in Britain. Some started saying, "Hey, this can't go on. Anyone who sets foot here and has a baby becomes our citizen?" They kind of felt like they were losing control of the situation. These debates, often tinged with racism and fear of the foreigner, gradually increased pressure on the government to do something about it. Finally, in 1981, the British government passed a new Citizenship Act, which came into effect on January 1st, 1983. This new law brought about a fundamental and major change. The right of the soil principle was no longer enough on its own. From then on, for a child born in Britain to become a citizen, at least one parent had to be a British citizen or legally and permanently resident there. What does that mean? It means if a tourist couple, students, or even temporary workers had a baby born in London, that child would no longer automatically become a British citizen. This was a huge change and moved Britain out of the category of countries with absolute right of the soil and into the group of countries that give more importance to right of blood, citizenship through parentage, or a combination of the two. Many European countries, Australia and New Zealand, now have similar laws. The reasons for this change were varied. The government said its aim was to make British citizenship more meaningful and to establish a more genuine connection between the individual and the country. They argued it would prevent abuse and immigration solely for the purpose of childbirth. But critics said the law was passed more for political motives and to control immigration, often with a discriminatory perspective. Interestingly, this change in law sparked a lot of debate and controversy even at the time. Some said it went against Britain's ancient and deep-rooted tradition. Others worried it would lead to children being born in Britain but being citizens of nowhere, becoming stateless, though the law tried to prevent this with certain provisions. So, Britain's story shows that even the grandmother of this law can change her mind. Social and political conditions and concerns about immigration led Britain to move away from the absolute right of the soil principle and impose some conditions. In a way, that magical soil that turned every newborn into a citizen lost some of its power. Now, just being born in London or Manchester isn't enough. You need to have some roots in that soil to be considered a citizen. All right, now that we've taken a look at the US, Canada, and Britain, you might be wondering which countries actually still adhere to that right of the soil principle or unconditional birthright citizenship, meaning where will your child automatically become a citizen if born there, regardless of whether you are a citizen or not? Let me be blunt. The number of these countries isn't as high as you might think, especially among developed nations. This law used to be much more common, but over time, many countries, like Britain as we discussed, changed their laws and added some strings. But there are still countries that have remained loyal to this principle. The main champions of this story are mostly found in the Americas. The United States and Canada. These two North American giants are the most famous countries that still have absolute right of the soil. As we explained in detail, despite some debates and challenges, the core law remains in place. Most Latin American and Caribbean countries. This is where things get really interesting. Almost all South and Central American countries and many island nations in the Caribbean have unconditional birthright citizenship. From Mexico, Brazil, and Argentina to smaller countries like Costa Rica, Panama, Peru, Venezuela, Ecuador, Bolivia, Paraguay, Uruguay, Chile, Colombia, and many others. It's a strong tradition in this region. Some say it's rooted in their colonial history. When these countries became independent, they wanted to increase their populations and give a sense of belonging to everyone born on their soil. Now, let's look at the rest of the world. Europe. Here, the situation is very different. Almost no European country offers unconditional birthright citizenship. Most operate on the right of blood, just sanguines, citizenship through parents, or have a hybrid model. For example, they might grant citizenship if a child is born on their soil and at least one parent has been a legal resident there for a specific period. Ireland once had this law, but later changed it by referendum. Asia. Absolute right of the soil is also very rare in Asia. Pakistan is one of the countries that has this law. Many other Asian countries either follow the right of blood or have very strict conditions for obtaining citizenship. Africa. The situation varies in Africa as well. Some countries like Tanzania and Lesotho have right of the soil, but many others have more complex laws. Oceania, Australia and New Zealand, like most Europeans, do not have absolute right of the soil and have placed conditions on citizenship for children born there. Usually, at least one parent must be a citizen or permanent resident. So, in a nutshell, if we want to have a mental map, the Americas, especially North and Latin, right of the soil is still very prominent here. Europe, Asia, Oceania, absolute right of the soil is almost a thing of the past here, and most countries have stricter laws. Why do these differences exist? There are many reasons, historical and cultural factors. Concerns about immigration and border control, domestic political pressures, and even sometimes economic issues all play a role in these decisions. Countries that were more open to immigration or wanted to increase their population tended to lean towards right of the soil. Those worried about waves of immigration or wanting to define their national identity differently changed their laws. So you see, this issue of birthright citizenship is a complex story full of details, and every country marches to the beat of its own drum.